All right, welcome back to another Cordell and Cordell Town Hall. I'm Scott Trout, CEO of Cordell and Cordell. And this is always, you've got questions and we've got answers, and we're joined by two of our attorneys in Cordell and Cordell. But as always, remember, we can't give you legal advice in this setting. It only can be done in a consultation, and that is a meeting with an attorney. And certainly we can do that as well. You can find information about consultations on our website, CordellCordell.com. You can schedule one right from the website. Don't even have to pick up the phone. You'll find information and our availability in our offices around the country, and you can schedule it right then and right there with one of our attorneys with our offices throughout the United States. Or you can give us a call at 866-DADS-LAW, 866-DADS-LAW, or go to the website, CordellCordell.com, and you get more information with regards to that. And that really is truly the only setting in which you can get really good legal advice, because each case has its unique nature, unique set of facts. And I've always said you can have the same facts in a case and 10 times out of 10 get different responses from a judge, different conclusions. And so keep in mind, this is informational, educational, and obviously with the two attorneys that we have, they are not going to be licensed in every one of the states in which you have questions. Speaking of which, if you have questions, it's the whole premise here today. Submit those in the Q&A section right now. You want to do that with your first name and the state or city that you are living in. And we'll try to make sure if one of our guests lives in your state or in your city, we'll go ahead and make sure we toss that question to them to get as close as we can to the right direction that we need to get you to. But submit those now in the Q&A section. We already have a few questions already ready to go. So let's start right away by introducing our guests. We have Morgan in Charlotte, North Carolina. Welcome.
Thank you for having me. As he said, my name is Morgan Rich. I'm in the Charlotte, North Carolina office, so I'm happy to answer any questions for North Carolina.
Thanks, Morgan. And then also joining us in Austin, Texas, Chantal. Welcome.
Thank you. My name is Chantal Crawley. I'm currently in the Austin, Texas office, but I'm also licensed in New Hampshire as well as Virginia. So any questions in those states as well, I'll be happy to help out.
Great. So get those questions, put them in the Q&A section. Happy to try to get you some direction today. We're going to talk a little bit about child support. That seems to be a real big topic, or even spousal support, anything financial in these difficult economic times when we're facing high inflation on the precipice of potentially a deep recession. So we're going to talk about that out of the gate as we get started. We have about 25 minutes or so together. So we'll talk a little bit about that. But first, before we get right to the heart of it, again, submit your questions now. We're going to take a real quick, brief break, and we'll be right back.
Holidays are hard for anyone going through a divorce. But I can tell you as a divorce lawyer serving men that for dads, holidays are especially hard, particularly for those grappling with a divorce that they didn't choose. Some of you have been there. But for kids too, those who are entangled in divorce, holidays are often less joyous than they should be. So I ask you to keep these dads and their kids in your thoughts this holiday season. A little encouragement this time of year can go a long way.
All right, welcome back. All right, let's talk, Chantal and Morgan, let's talk generally as people are submitting their questions. I want to talk about child support, and we have a number of questions here that are really on that topic, spousal support as well, that obviously whether it's back in 2006, 2007, 2008, we had kind of a similar situation where we had high unemployment, or we had very difficult economic times. People were losing their job, making these judgments untenable, unreasonable, not even workable. So Morgan, what are you seeing? First and foremost, I guess the big question post-COVID, which has seemed to cause ripple effects around the country throughout our court system. And that is the time in which it takes to get to a hearing, to get to a trial, to get some relief. What are you seeing in North Carolina with regards to the timing, how long it's taking once you're filing, whether it's a divorce or a modification, something to get some relief?
Sure. So North Carolina, it all depends on the county that you're in. Charlotte, we are right in the heart of Mecklenburg County, which is the largest county in North Carolina. Mecklenburg County takes months to even get a temporary child support or spouse support hearing heard. What I always advise is to go ahead and file as soon as you can, as soon as the need is there, because even if it takes a while to get that court date, at least once we finally get that court date, it backdates to when you file. So we find a lot of people who come to us months and months after they've, lost their job or they're on unemployment. And as soon as we file, we can help. But you've got those months where you're stuck, where you're expected to pay. If you already have an order in place, you're expected to pay what's in the order. Or if you have an order and you haven't filed yet, what's really important is to make sure that you go ahead and file. What we are seeing, thankfully, is COVID seems to not be affecting our courts as much. North Carolina is a state where we move a little slower than some states. We don't have electronic filing yet. We are working towards it. So in the smaller counties, Gaston County, Iredell County, around our area, we're able to now get temporary hearings within a few weeks sometimes. So it really depends. If you've got the smaller counties, let us know. We go all around. For example, I just had a hearing in Gaston County where I was able to get a court date for 12/14. So I did that last week, and that's kind of how quickly it's going. But what's really important is to make sure that you can file so you can get that. The date of filing is important because we can backdate and get you at least some relief up till that.
That's really aggressive in terms of, here in Missouri, we're taking months and months and months. I'm just now getting to court to just get a trial date, and I'm 2 years in, and it's crazy. Everything's so backlogged. So what's happening in Texas, Chantal? What are you seeing in terms of the ability to get to court to get some relief, whether it be temporary or even a final hearing, depending upon the type of matter?
So I would say it's very much like what Morgan said. So in Texas, the smaller counties, Caldwell County, Bell County, or Milam County, we've gotten quite a few cases on Milam County recently. As long as there are no jury trials in place, we're able to get hearings pretty quickly. The problem is with those smaller counties, when you only have one judge present, if they have jury trials on their docket for the next 2 months, the clerk's going to try and fit us in if there's a cancellation one day, and they know that. But we have to set the hearing dates pretty far out. Now, if there are no jury trials in those smaller counties, we can probably get a hearing date within a week or two. And it all really depends. But the positive is Texas does have a lot of e-filing. Some of the counties, such as Williamson County, are still doing Zoom hearings. So sometimes the clerks are able to fit us in with a Zoom hearing rather than an in-person hearing, depending upon the judge. And still, then it really depends which judge did your case get assigned to when you filed. So sometimes that's the question. Now I can tell you, since I just came to Texas from New Hampshire, in New Hampshire, you're still in paper filing. So, but the positive is the clerks, you answer the phone, they'll give you the first date available to them if you're not able to settle it in mediation. So at least what I tell my clients is try to get into mediation. That's probably going to be faster than getting to a hearing date. And if we can resolve something, get something, even if it's just a Band-Aid for a little bit during mediation to get to that hearing, that's going to be better than what they're currently doing.
So staying with you, Chantal, what are you getting from the judges in terms of their reaction to this economy? High inflation, everything's more expensive. I mean, it doesn't matter where you go. It's crazy, crazy expensive. And so it's putting pressure on people to afford anything and everything just to kind of make ends meet, much less meeting the needs and obligations contained in a judgment of divorce. So child support. Are judges being receptive to it? What are you seeing and hearing from the bench?
So mostly what I'm hearing is that as long as it is your current income, the judges are saying the guidelines are the guidelines. And that's in both New Hampshire as well as Texas. So then the battle is if you're having increased expenses, such as you have kids who are not part of the action at hand, you have to really show to the judge your finances, those expenses that you're doing, and ask for deviations from the child support guidelines. But they are respecting the fact that when families are coming to agreements and saying, you know what, neither of us really can afford it, we don't think the child support is appropriate, then they are respecting that and they're going ahead and signing those orders as long as you can reason that with them.
Morgan, what are you seeing in North Carolina?
For us, we also follow the guidelines heavily. You can file a motion to deviate. Judges rarely deviate from the guidelines. Our guidelines, at least North Carolina as well, are being amended again. So starting January 2023, the guidelines are increasing the percentage that child support goes from your paycheck. So it's going to be a higher amount overall for all cases.
Mhm.
But what we're seeing with judges is, say if someone's in unemployment or they're not able to work the full 40 hours, a lot of times now, instead of having a permanent order and just having that, they're setting reviews instead. And they're saying, okay, I want you to show that you've applied for 60 jobs a month, show, that you have a doctor's letter, show that you're taking these efforts to find more employment or a higher paying job if you can, based on your education and what you were doing during the marriage. But they're being understanding that it's difficult. And they're taking that into consideration when they do the guidelines.
So it's a good entree to our first question that's in, but don't forget, submit your questions now to the Q&A section. We're going to get to those now in the final 15 minutes or so that we have to spend with you to try to get you some direction, the questions that you have. So Morgan, I'll just stay with you with the first question that comes from Minnesota. Corey was let go from his job a few weeks ago. HR said the position was eliminated. They offered Corey a severance package and stated they will not contest if Corey applies for unemployment. However, he just needs to sign the paperwork, which I imagine Corey will do. Corey wants to know, do I file for a motion to review child support now that I've been let go and have no job? But I have a severance. So that comes into play, I guess.
Immediately. I would file immediately. As I said earlier, the date that you file is what's important. Even if he loses the job and he takes 2 or 3 months to file, per the order, you are expected to pay what the previous order said. It only backdates to when you file. So you want to go in and file that modification for child support immediately, and then start seeing if you can negotiate in actual terms based on your new numbers. Sometimes lump sum payments can be taken as income in North Carolina. It all depends on the amount, how it was occurred, and kind of what the future holds. If it's a one-time lump sum, it's usually not equated in it.
Yeah. And I think one of the things we talked about last month in the Q&A was a similar situation where some of the states look at a continuing change, meaning is this a permanent change? What's the employment situation like? Although unemployment rate tends to be lower, we're starting to see it uptick and starting to see. So as I think you suggest, obviously file now right away to try to set the clock. At least gives you some relief going backwards. It's very important. But more importantly, get in for a consult. You want to have that discussion, know what your options are, and then you can make informed decisions. So, all right, let's go to Matt has a question. Chantal. Matt bought a house before he got married. Only his name is on the house as well as everything to do with the house. None of the paperwork has my soon-to-be ex-spouse's name on it. And I paid for everything myself, even after we were married. That may be the key part. Matt lives in New Jersey. He wants to sell the house. Does his wife, soon to be ex-wife, have any claim to the profit he's getting from selling the house?
Now, this is actually a pretty good question. And it's something that I've recently ran into. And it was, I guess a year ago. So in that case, what we did, and of course, this is all state by state based, and it's based upon the case law in your state. So what we were able to do, the short answer to this is yes, your wife does have a claim to a portion of the sale of the house. However, what we were able to do is we were able to show the amount of investment that our client did prior to the marriage and account for that. And as long as we had that paperwork, the judge said, you know what, I'll give you that credit for that amount of money. And so when it came time for our client to pay out the equity, because he didn't want to sell the house that he had built, he was able to carve out that amount. And the judge said, you know what, you only owe 25% of the equity rather than 50% of the equity. And that was a pretty decent resolution for him after the final.
And every state, obviously has its own peculiarities as it relates to separate property. And I'm curious what North Carolina, and I will chime in on what Missouri does, but what is North Carolina? How do they treat that?
So North Carolina, we have an overall presumption. Anything acquired before marriage is separate property. Anything acquired during the marriage is presumed marital. So in this situation, it's a little interesting, and we deal with this constantly. The house is separate property. However, the principal reduction on the mortgage from when you married is marital. So in this instance, a majority of the equity would likely be his own personal separate property. But depending on when they were married up until date of separation, which is important for us, that principal reduction, she has a right to a percentage of that.
Mhm. Yeah. So Missouri, I'm actually in a case very similar to what's going on with that, where I mentioned what the key phrase or question was said, looking fine. I have paid for everything myself. So obviously they're married. So his income is marital. So in Missouri, the income that he uses, because one of the first questions I have is, are you paying taxes on that property? You're using marital funds to pay the taxes. As you see, you're using marital funds perhaps to pay the mortgage, the principal, the interest reduction, as we go down. Some of those we get set aside, kind of your contribution, and we set off just kind of what it did in terms of the amount of money you used. And there could be an argument, obviously, to the increase. Let's say his spouse contributed towards the increase in its value by helping make changes to the house, make improvements to the house. Obviously, those are some of the factors as well. But I think, again, as Matt indicates, it's certainly a conversation to have with an attorney to make sure that you get the right thing before you even try to sell it. There may be some standing orders in place that prohibit you from doing anything like selling a piece of property, even if it's separate. So certainly consult with an attorney before you do anything. All right, let's go. And again, submit the Q&A. I know there's a question about someone submitting questions beforehand. Hopefully, if not, we can address them if we haven't done that. So let me get to Craig in Washington. Oregon. I live in Washington State, Craig has been divorced for 4 years. Craig shares custody of his 5-year-old. At the time of the divorce, his ex and Craig had similar salaries. Child support was $200 a month with no spousal support. Craig pays health care. When the child was young, family members would watch the child, but recently nannies have come into the equation. We're both remarried, have had additional children, and both have nannies full time. My ex is asking that I help share her nanny expenses. Does she have any legal standing to ask me for nanny expenses? We agreed to share childcare 50-50 in our mediated agreement.
So North Carolina, as I stated earlier, we revise our guidelines about every 3 or 4 years. So our guidelines are being revised. They've already been revised, but it's starting January 2023. All of this that is, new children, healthcare, childcare, all of that goes in the child support guidelines. And per the statute, you're allowed to go back and revise every 3 years. So yes, she has a claim to try to include nanny expenses if it's during work-related childcare, but so does he if he's got nanny expenses. You also receive credit if you have children under your roof that are not the children to this party. So I would say it's probably important to go get a consult to run the guidelines and see what the numbers look like. And then depending on what those numbers are, go back in for modification.
Yeah, and I think one of the things that I would point to is in our child support chart, it's reasonable work-related childcare expenses. So the question really becomes, yes, a nanny is a luxury that many won't employ. So the question becomes, is reasonable work-related? And they both, and as you suggest, when you have children from a different marriage, you can use that as what we call the shield rather than a sword. You can't go and file a modification, use your children to reduce your income, but you can use it to defend against an increased potential. But I think you're right, using your own work-related expenses as an offset. So maybe if your income is similar, it probably may not be a big difference. And it's worth an hour. Get an attorney to run a child support chart for you so you know what to expect if she does try to file. All right, Chantal, Jackson. Well, let me skip that because that's North Carolina. So I'm going to come back. Let me go to Josh, actually. Josh, my wife left the state with our kids on a planned trip to visit her family over Thanksgiving. She blindly had me serve divorce papers while she was gone. She'll be bringing the kids back after the trip. Moving forward, I'm worried that she may be a flight risk with the kids since her family and friends are primarily out of state. Is this enough for me to get some type of injunction since I feel she is a flight risk?
So first thing I would advise is look over those divorce papers. In some states, whenever the divorce is initially filed, there's actually already an injunction in it. And that means that your wife can't just move the kids out of state. Now, if that's not in there, So for instance, in Texas, when you first file for divorce, that's not in there. Somebody could move their kids out of the state, but it is in the standing orders of every single county. So I did recently run into this, and it was actually right as we were filing for divorce, mom took the kid out of state. So what we were able to do is we were able to file for temporary orders. We were able to file what's called a temporary restraining order. It's not a protection order, but it was a temporary restraining order, and it was restraining mom's actions from taking the child out of state and keeping the child out of state. So what then was required was that mom met dad. Dad went to the other state, went ahead and picked up the kid, and mom was required to go deliver the child to dad. And then dad was able to bring the child back to the state of Texas. So you need to look into it. In a place like New Hampshire, you would need to file if you had actual evidence that mom was intending to leave the state, not just a gut feeling, but actual evidence. You could go file an ex parte emergency motion with the court, and the court would stop that and say, look, you can't take the kids out of the state until there's a further order from the court or an agreement between the parties. So first and foremost, I would say look at your divorce pleading, because it might be in there stopping that already, and maybe she didn't realize it.
All right. Let me get we have about 6 minutes left. I think we have enough. We have a couple questions. Let me go to Morgan, the North Carolina question. Is an IRA, traditional or Roth, that has been funded during the marriage considered a separate or communal asset? So it's a IRA funded during the marriage. Not sure if it was created before or after, but it says funded during the marriage, considered a separate asset.
No, so that would be considered a marital asset that needs to be divided. Again, say if the Roth was started before marriage, so let's say 3 years before marriage, whatever was added to the Roth IRA for those 3 years is separate property. However, anything after date of marriage, again, till date of separation, not date of divorce, date of separation, is presumed marital property. And then it becomes a matter of how are we dividing this? Does she have a Roth IRA or some other retirement account as well, to see if those balance out and how those should be divided?
Yep. All right. Chantal, a couple questions from Minnesota. The first one, and we'll break these up since there are a couple questions here. The divorce decree is from December of 2021, gave all of the tax exemptions to my ex-wife, starting with the tax year of 2022. She, however, filed her income taxes for the 2021 year back in 2022. When I went to file for that year, later in March, she told me she listed all 4 children as dependents, stating the decree says she could. I was told that since she claimed all 4 for 2021, I was not allowed to claim any. I pointed out to her that she was wrong, but she stood her ground. I was forced to file my income tax with no child tax exemptions, and I should have been able to claim 2. Since I received tax credits for the 4 kids from the pandemic and split those monthly checks with my wife during 21, but did not claim any of the kids in my income tax, I had to pay back the money, but also a penalty of thousands of dollars of more taxes. The question becomes does he need to get a lawyer to take her to court for a resolution? Is there a resolution since the decree is silent? It only references the 2022 year and forward. That's really the first question.
So what I would advise in either, I'm not licensed in Minnesota, but what I would advise in any of the states where I am licensed is what we would do would we be filing a petition to change the court order or a petition to clarify. The problem is generally that clarification needs to be done within a short period of time after the final order. So since this has affected your case for the 2021, I would ask the court personally and take your ex-wife to court for a motion to clarify the divorce decree to address solely this 2021 issue. Because since the decree is silent to that, and you have now been damaged, the IRS is wanting penalties, the IRS is wanting you to pay back money. You do need some relief from the court for this, and the court could find a way to have her make payments to you to make up for that.
Yeah. And then the question about dealing with the IRS directly, and they won't. They're just going to say deal with it in court. So you'll have to do something if it's available to you in Minnesota. So Morgan, the second question from the same attendee is at the beginning of this month, November of 2022, my wife acknowledged verbally that because she has been cohabitating with her boyfriend since March that I could stop paying alimony because of the new law that was passed that allows that. But last Monday, when I asked her about it again, so we can enter a stipulation agreement to the court, she denied ever having that conversation. Is my only recourse to file a motion with the court, and I assume I'd have to hire a lawyer to follow through.
Yeah. So again, I'm also not licensed in Minnesota, but here in North Carolina, spousal support cohabitation is one of the factors to terminate spousal support payments. Cohabitation is a tricky area because at least here, it's all based on the totality of the circumstances. And how are you going to prove that she's cohabitating? He said, she said, with no written confirmation, no pictures, is difficult to meet that burden to set aside alimony. So what I recommend is have the consultation, talk about possibly a private investigator or way of finding out addresses, who this person is, PO box, where they live, how often, and then going in to file the motion. It's in this situation, you want to be smart long-term goal-wise on how and when you're going to file the motion. You don't want to set her to where she has noticed that you maybe have a PI or something watching her, but you also don't want to wait too long.
Yeah. And I think Bridget Landry, who's in our Minnesota office, would be the perfect person to have that conversation with. But following up on that, we have a similar case that's happening now with the same allegation here in Missouri about cohabitation, and we're using their bank accounts and the sharing of expenses and who's paying what on the mortgage, Facebook posts. We actually have proof that they're living together and who's paying for the mortgage, and showing that the need is no longer there, obviously. And obviously, if there's a new law that allows cohabitation proof to be a termination, Missouri, it's just death or remarriage. Cohabitation can be a factor when you can show a decreased need. But certainly, again, having a conversation, determining if the proof that you have is enough to move forward or wait and try to gather more is probably the best course of action. All right, last question we have for our town hall. Chantal, it says, I share custody with my ex 50-50. With the holidays coming up, splitting the time with the kids has become an issue. I'd like to avoid unnecessary court legal costs to hash this out. What are some typical holiday split options? This person's in California. The kids are 5 and 8.
So this is actually a great question. In New Hampshire, everything is default 50-50. And then as the default of 50-50, there's a nice outline of the holiday plans. So normally if I'll pretend like you're in New Hampshire because this might be a good plan for you. So if you and your ex-wife are living close together, I would advise that you guys find a way to split Christmas Day in half. If Christmas Eve is more of the important holiday for your family, you find a way to split Christmas Eve in half. The ideal situation is when for one family, Christmas Eve is more important, Christmas Day is more important for the other family, you can just split it right there in the morning. And but you need to really sit down with your ex-wife and figure out what is going to be the most important for your family. And it's going to be a lot of exchanges over that week and a half. But to make it best for your kids for Christmas Eve, for Christmas Day, and for New Year's, just try and figure out a way to split it equally and make sure that each of your families are able to see the kids. I would suggest that if that is not in your parenting plan, that you guys do sit down and think about next year and try and come up with a plan to move forward every year after this. So that way you have that basis to go into whenever there are conflicts in the future.
Yeah, and there's sample parenting plans from around the country that you can use for guidance. Like in Missouri, it'd be just using Christmas as an example. One parent in 1 year gets Christmas Eve overnight and has to return the child by, say, 9 or 10 a.m. on Christmas Day. And it may be that maybe you like Christmas Eve versus Christmas Day. Maybe that's a family thing. You may agree to share it that way, or you always get Christmas Eve and she always gets Christmas Day. Thanksgiving tends to be a little bit different in our parenting plan, where you alternate every other year. But great parenting plan options around the country. You can Google, those forms are online. You can use that as a basis to try to negotiate and settle it without hiring counsel, but obviously you want to file it and make sure it's done. All right, follow-up question with regards to the cohabitation real quickly, and then we'll end. And the question was, I know the car's there overnight, and the 4 kids also state that the boyfriend lives there, plus my wife doesn't deny that he's living there. The question is do I hire a private investigator? And I'll respond, and Morgan, Chantal, you can chime in. I still think it's about having a consult. Let's figure out what really you need from our perspective. And then Bridget, like for example, I mentioned Bridget Landry up in Minnesota. She'll know the judges, she'll know the courthouse, she'll know kind of what's happened before and the level of proof required depending upon the judge that you're assigned, because every judge is different regardless of the law. So Bridget Landry up in Minnesota, you can contact us and schedule an appointment with her, and she certainly will give you the right guidance. We have a number of attorneys up there, but she's a senior litigation partner who would know most about those counties as well as following up. So any final thoughts, Morgan or Chantal, on that?
For me, just because I know in North Carolina, cohabitation is a way to terminate alimony. And the consultations is where we really sit down and we game plan and we say, okay, this is what we need to do. It's all about what you can present to the judge. Our judges here, at least, are very evidence-based. We kind of weigh the pros and cons of a PI versus not, because a PI is someone that can testify on your behalf with reports. And then also thinking about the age of the children. Do you want them in that position of testifying? But in this situation, it's very case by case and very fact specific. So it's important to really game plan it short-term and long-term wise.
Yep. Chantal?
Well, yep. I would add in that Texas doesn't have alimony, so that's really not an issue in Texas. However, in New Hampshire, it is a significant issue. So the standard in New Hampshire is you hire a PI to watch your ex-wife's house for a week because they do not want the kids in court. Now, New Hampshire does allow hearsay evidence, which means the statements of your kids would be allowed into court. However, that's still that he said, she said. So if I would encourage, if you were in New Hampshire, I would be saying, go ahead and hire a PI to take photos at 5 o'clock in the morning. She's probably not going to notice. Then that PI can show up in court and testify on your behalf. And you have those photos at 5 o'clock in the morning. I would caution, do not drive over there yourself, because then you might get hit with a protection order or an anti-stalking order. So make sure you hire a professional to do that should you choose to go that route.
All right, that's all the time we have. Thanks for joining. We're going to skip December and let you enjoy your time and your holidays, but check out our Facebook and social media posts for our next virtual town hall with You've Got Questions, and we'll give you the answers in January. But in the meantime, for all of December, you can check out our podcasts. Subscribe to Apple iTunes, check out the podcast. We'll be dropping those throughout the month as well. And you can go to our YouTube channel. It's filled with information, previous town halls, and podcasts just like this. So until next time, have a wonderful rest of 2022, and we'll see you next year.